Our next speaker is Dan Stephenson. Dan leads Dykema's national trial team. He's been the firm's head of litigation and managing member of the firm's Los Angeles office. Dan's practice focuses on pharmaceutical, aviation, and consumer product industry litigation. He has a bachelor's degree in mechanical engineering and is a member of Tau Beta Pi, an honorary mechanical engineering fraternity. Dan has written on commercial damage claims and aviation litigation. His thorough research and understanding of the scientific and technical aspects of cases allows him to translate difficult and complex concepts to a jury. He has represented clients from the financial services, coal mining, computer, glass, telecommunications, and energy industries. He's numerous publications and reported decisions and is a former board chair of the Michigan Theological Seminary. And if that wasn't enough, Dan is also a world-class competitive swimmer and author of The Underwater Window, a novel set in the world of Olympic-level swimming. Here to speak to us today about destroying expert witnesses, please welcome Dan Stephenson.
Thank you. Good morning. My topic today is cross-examining the impeccable expert, and there's a word you don't see every day, and there's a concept you don't see in every case, an impeccable expert on the other side. My friend and fellow network trial lawyer Mike O'Donnell had a case one time where the opposing expert, they discovered through good lawyering, resided in a trailer in a nudist colony. That is not an impeccable expert. The impeccable expert that I'm talking about is the expert who is really good, who has great credentials, who is likable, who gets past Daubert, or you don't even have a chance for Daubert. So you don't encounter that type of expert every day on the other side. We're all used to seeing the bogus expert, and we all have a lot of fun in kind of dismantling the bogus expert. That's one of the highlights of being a trial lawyer. It's one of our favorite things. It's a little different. It's a little tougher when you have the impeccable expert on the other side. So let me talk about it a little bit. The stakes are pretty high when you have a really good expert on the other side. And the reason for that is that the jury is going to ascribe a lot of weight to the impeccable expert. And it could be good weight or it could be bad weight. It could go your way or it could go the other way. And the thing that is really important about encountering an impeccable expert on the other side is that you have to go in with a plan. You can't just muck around, because that will make the impeccable expert look even better. But if you can get some significant admissions out of the other side's really good, credible expert, then you will score big points at trial. This is a statement about the value of cross-examination from John Henry Wigmore, which I think when I came out of law school, Wigmore on evidence was the biggest treatise that people cited. Cross-examination is the greatest legal engine ever invented for the discovery of truth. You can do anything with a bayonet except sit on it. A lawyer can do anything with cross-examination if he is skillful enough not to impale his own cause upon it. And I think what that illustrates, especially in the case of the impeccable opposing expert, is that you can do great things if you use your bayonet correctly, but you can also hurt yourself if you use it wrong. So here's sort of a list of what an impeccable expert looks like. I mentioned a couple of these things already. It's not the professional witness who testifies all the time. It's usually a practitioner in the field, somebody who has a great resume, somebody who you're not going to be able to knock out for lack of qualifications, somebody who has really done research, has looked at the relevant facts, the relevant depositions and documents and things like that, but perhaps has even done some experimentation, some testing of his own. It's not the person who is being paid $850 an hour. I think you can use that as fodder for cross-examinations. A lot of experts are way overpaid. We're talking about somebody who you really can't find an Achilles heel on. So that's kind of the general approach of what an impeccable expert looks like. And I'm going to talk about one that I encountered in the course of a big headline-grabbing case involving an airplane crash. This is a war story, and this case was indeed a war. This was the crash of Flight 255 in Detroit. It was a crash on takeoff. The plane was full of passengers, full of fuel, and big explosion. 156 people killed, including a few on the ground. And this was in Detroit. And one of the interesting things about the case is that one little girl survived, and it made it a massive human interest story. So a lot of days during the trial of this case, there were news crews present outside the courtroom. They weren't allowed inside. But it was a story that lingered on, and it was a very big human interest story. The middle picture there is a photograph of what the MD-80 airplane looks like behind the captain's seat. And you can see there's a row of circuit breakers on a panel behind the captain's seat. Let me tell you what's important about that. Flight 255 took off and crashed because the pilots failed to set the wing flaps. There's a checklist item that requires them to do that. They skipped the checklist. So the plane took off with insufficient lift and entered an aerodynamic stall immediately after lifting off. The wing clipped a light pole in a rental car parking lot. 18 feet of wing got sheared off. Plane flipped upside down, hit a building, and crashed into an intersection. And the pilots were obviously negligent in failing to set the flaps, but one of the biggest issues in the case was that there was a warning system in the plane that was designed to warn pilots with an audible warning, flaps, 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 in the case they didn't set the flaps for takeoff. Within 24 hours, the investigators determined that that warning had not sounded, and the question was why. Ultimately, through a lot of great engineering and investigative work, they determined that the power to the warning box was not passing through a particular circuit breaker. And you can see there's dozens of circuit breakers in the panel behind the captain's seat. This was the P40 circuit breaker, meaning number 40 in row P. So dozens and dozens of circuit breakers, and this is one. It's a $5 little, this big circuit breaker. And there's a more than full-size picture of it there on the right. Now, the question at trial, ultimately the trial ended up being between the airline and the airplane manufacturer. We represented the airplane manufacturer. And the airline contended that the P40 circuit breaker had malfunctioned, and therefore current to the takeoff warning was interrupted. And on behalf of the airplane manufacturer, we argued that the P40 circuit breaker worked fine, but it had been manually disabled by the flight crew, meaning a circuit breaker like this, you can just pull it out. Like a circuit breaker in your house, you can just flip the switch and turn it off, interrupting current to that circuit. So that was the big issue at trial. Had the crew pulled the circuit breaker, or had the circuit breaker malfunctioned? Obviously, both sides had prestigious circuit breaker experts. And this is where I encountered the impeccable Dr. Lee. One of the problems was that The plane blew to smithereens in the crash. And even locating the P-40 circuit breaker was kind of like finding the Malaysian airliner in the Indian Ocean. The wreckage was strewn everywhere. They ultimately did find all of the pieces of the P-40 circuit breaker. It's a little thing this big, and it was blown into 6 pieces. But they were able to find all the pieces. It took 3 months to do it, and some of the pieces had been exposed to the outdoors. And Dr. Lee, the airline's expert circuit breaker expert, he was able to do tests on the circuit breaker pieces. So these are the credentials of the impeccable Dr. Lee. MIT professor, had designed and gotten patents on circuit breakers himself, had been a practitioner in the field. He had a very compelling personal story, having escaped from communist China, and he was just a delightful gentleman. Daubert was not an issue. He'd done extremely well in his deposition. In fact, the whole deposition was pretty much useless on cross-examination. So I got the assignment of cross-examining Dr. Lee. This was an 18-month trial with 6 weeks of jury deliberation. We had a big trial team, and I was one of the lawyers on the trial team. I think I drew the short straw in getting Dr. Lee to cross-examine. And I had to figure out a plan. What am I going to do with this guy? He's got great credentials. We didn't really get any good admissions in his deposition. What am I going to do? Dr. Lee did great on direct examination. He testified that the P-40 circuit breaker was, in fact, defective. There were a lot of bad documents out there. Among them were that the circuit breaker could be manufactured with gaps in the case, which would allow contaminants in. And the contaminants could increase the resistance of the electrical contacts, therefore impeding electrical flow. The NTSB had tested the circuit breaker components and determined that they didn't see anything that would prevent the flow of electricity. But Dr. Lee said the tests they did were insufficient because they were just alive versus dead tests. And what you really wanted to know was whether the circuit breaker was sick or healthy. And so he analogized to a little boy going to the doctor, and he said, Johnny, the patient in issue here, was sick, not healthy. And he gave that testimony right at the end of a day so it could soak in on the jury overnight. And I got to do cross-examination the next morning. So, of course, I planned the cross-examination about a week in advance and literally did not know what to do starting out. Read the deposition, nothing good in there. I just locked myself in a room for 5 days and poured through all of the evidence, all of the notes, and everything. Because Dr. Lee had testified that the circuit breaker was sick and not healthy, I decided that was the analogy that I really needed to go after. The first thing I decided in coming up with a plan for cross-examining Dr. Lee was that because he was so likable and so credible and his resume was so strong, that I would have to be respectful to him. I could not yell at him. I could not even interrupt him. I would have to be respectful and polite to him. So that was number one. That was the biggest part of the plan. Second part of the plan came while I was studying these handwritten notes of his in a windowless conference room in Detroit. Hieroglyphics, rows and rows of numbers. And he had testified that the resistance was high on the metal contacts. And as I looked at his numbers, I didn't see any resistance numbers. All I saw were voltage and current. But then I remembered, hey, I studied engineering. Ohm's law, remember Ohm's law from Jerry Glass's presentation? The coroner in Louisiana who didn't know what Ohm's law was, he was testifying in a taser case. Ohm's law is not really super well known to people, but actually it's simple. If you know voltage and current, you can calculate resistance. So what I did was I took Dr. Lee's hieroglyphics, rows and rows of numbers. I took his voltage and current numbers and calculated resistances. And while he had given this sort of broad, sweeping testimony that the resistance was high and therefore the circuit breaker was sick, as I actually calculated the resistances from his numbers, they were pretty low. And so I determined that I could use that. But it presented a challenge because I had to rely on Ohm's law, which people don't generally know, and I had to rely on the ability of people to understand the math. Oops, I think I covered that. So I decided to take a sort of a calculated risk. I was going to go after it. I was going to go after his statement that the circuit breaker was sick. And what I did was, very, very respectfully, very politely, asked him about the numbers on his handwritten notes. And I had calculated all the resistance numbers ahead of time, so I knew what they were. He had given me a golden nugget on direct examination because he had told me what the threshold was for sick versus healthy, 1/10 of an ohm. If it's less than 1/10 of an ohm, it's healthy. And I reminded him about that early on. And then I asked him very methodically what the resistances calculated out to be on his rows and rows of numbers in his handwritten report of his tests. He's the only one who did these tests. Even our expert hadn't done these tests. So fortunately for me, he was in fact a consummate professional, and he didn't fight me on it. And so as we went down, he gave me the resistance numbers and I wrote them on a flip chart, and every single one of them was less than 1/10 of an ohm. And then at the end of all that, after I think the jury was following it, I had to decide whether to ask the payoff question. And the payoff question was, okay, you said that under 1/10 of an ohm and it's healthy, and all the numbers we just wrote on this flip chart are under 1/10 of an ohm. So that's healthy, right? That was the payoff question. And he answered it, yes. And we went down and we established that all of his numbers, all of his calculations, all of his measurements, everything he did with the P40 circuit breaker showed that it was healthy and not sick. So, the question is, how did we get from the key expert in a huge case saying at the end of one day that the key piece of hardware in question was sick, and 24 hours later admitting that it was healthy? My kind of synopsis of how this went down was that there were three things that were critical. And I've actually done a little research, and I didn't want this to be just my war story, but I've talked to some great trial lawyers. I've read articles about what great trial lawyers say make them great, and I have a couple of ideas. I have a couple of points that I would offer as tips for how to handle the impeccable expert on the other side. The first one is, I believe that the demeanor question is critical. You remember when Roger McCleary was cross-examining the two experts that he had video clips for? Quiet, calm, methodical. That's what I'm talking about. It's not yelling at the expert. It's because the impeccable expert is, by definition, likable to the jury. And you want the jury to like you every bit as much as the jury likes that person, if not more. So you have to have that demeanor. You have to have the likability factor. You can't bring fire and brimstone on an impeccable expert. So that is my number one point. If you have a bogus expert with with bad qualifications, it may be appropriate to yell at that person, make him look bad, but not the impeccable expert. You have to be polite and respectful. You can do it. You can be firm, just like Roger McCleary was. You can be firm and ask tough questions, but you have to be polite and respectful. The second thing is preparation. And this is the one thing, if you ask any of the great trial lawyers in this room, if you ask any of the great trial lawyers outside of this room, what's the key to a great cross-examination, especially a great cross-examination of an impeccable expert? You'll find things like, well, I wake up at 4 in the morning. When I'm in trial, I get 2 to 3 hours of sleep. I do things like bolt myself into a windowless conference room in Detroit to study handwritten notes. Those are the kinds of things that win the case against an impeccable expert. And so preparation is absolutely essential, and developing a plan that you can use with the impeccable expert. And then the third thing on here, and I'm going to close with this, is you have to be prepared to take calculated risks. The key word there is calculated. I'm not talking about taking wild risks. We all know there's some great examples of people who asked one question too many. Just didn't know what the answer was going to be and fished for it. You cannot do that with the impeccable expert. You have to be calculated about it. And I took some calculated risks with Dr. Lee. It was a risk to go through the numbers and use Ohm's law. If he hadn't followed with me, if he hadn't been that true scientist who agreed with my presenting of the science, if he'd fought me on that and I had to use Ohm's law and the handwritten numbers, it would have been tough. It would have been tough. But I did have those things to box him in. And that's kind of the key to the calculated risk, is you come on it slowly. You box him in so that if he doesn't give you what you hope to get, the downside is limited. And so it is important for a good cross-examiner, especially in the case of an impeccable witness, to take some risks. But you got to lay the foundation for the risk and box the expert in so that the risk isn't a wild one. So, bottom line, the impeccable expert is one that you will encounter, not in every case, but if you do encounter him, you got to be careful. You got to have a plan. You got to have true trial mastery to guide you through it. You don't want to go through cross-examination of an impeccable expert with a rookie. Go with a true master who knows how to use those instincts and good judgments. Prepare like crazy. Be respectful. And box in the risk. Thank you.